Great. And just as said, if you have any questions, we'll try to take them as we're talking. So please put any questions you have in the chat, and then we can also circle back at the end of the presentation if we still have time to try to answer any additional questions. And we have because we're lawyers, we have our disclaimer slide that says this isn't legal advice. And also because we are talking about some legislation that is pending or has been proposed, it very well could change by next month if we get more regulations that come out. So just be aware of that if you're ever circling back to this presentation. So welcome to 2023. It's similar to 2022 in that we've got a lot of continued uncertainty and change, but we do think that it looks a little different this year in that we're seeing more action, more rulemaking, more court decisions and enforcement, or at least it is highlighted to be forthcoming. So when we were looking back at our presentation for 2022, we were describing things like interagency cooperation, like memorandums of understanding. We're still dealing with COVID issues, and I would love to say that is completely gone, but you probably will hear COVID today in our presentation as well, unfortunately. So we were identifying last year areas where you should be focusing and doing some policy updating, but we didn't have a lot of new law or regulations to flag for you. But for 2023, we've got more concrete things to share. And so we're going to inform you about those things today. Some of it is still pending, some of it's proposed, some of it is actually law. So that's where we're going to start, the things that are new. So we have new laws, new regulations, new administrative decisions or court decisions. And then we're going to highlight for y'all additional areas that we think you're going to be likely to see something new in 2023. So with that, I'm going to let Natalie take the first topic.
So this one's been in the news a lot, so you've probably heard about it already. The Federal Trade Commission put out a proposed rule January 5th, and this is what it says. It's very broad. It prohibits anything that is going to prevent a worker from seeking or accepting employment with someone else after they leave your employment. So it's very broad. It even goes on to say that functional equivalents are prohibited. And so that's something that's basically so broad, it is de facto a non-compete agreement. So that could be something like a non-disclosure. It could be something related to repayment of training costs or some sort of liquidated damage, those types of things. Yet, why are they doing this? You had a little statistic there on the slide, but basically, the FTC has looked at it and said there's a lot of people under non-competes and a lot of people they don't think should be. And then they also looked at research and said that in states that already prohibit non-compete agreements, there is less wage inequity, there's higher wages, and more development, more competition. So that's why they're really looking at it. That's why they came to these rules. There is an exception, but only one, and that's the sale of a business context. And then it's limited to someone who is a substantial owner, and they've defined that as 25% ownership in the business. So if there is that sale, then possibly you can have a non-compete. But they flagged that the antitrust laws still apply. So this is a proposed rule. It's not final. The comment period is open through March 10th. And we know there's going to be legal challenges if it does become final. And even if some different version of it becomes final, there's likely to be some legal challenges. But most notably, the U.S. Chamber of Commerce has said they'll sue if this is what ends up being the final rule. So what does all this mean? It means there's definitely a decline in non-competes and their enforceability, even without this rule. So let me put it into context just a little bit. The day before the FTC put this rule out, they handed out an order against 3 different employers invalidating their non-compete agreements as being unenforceable because they were an improper restraint of trade. So even without the rule, the FTC is actively out there looking for non-competes that are unfair methods of competition. Plus you have states, a lot of different states are already implementing and limiting non-competes, and they range. Some of them are just saying there should be a minimum compensation level if you're going to impose a non-compete on an employee, and others go extreme, like the FTC, and say they're not appropriate at all. So our key takeaways, go ahead, review your non-compete agreements, because even in the states that are still allowing them, there are rules about how broad they can be, whether or not they're enforceable. Start thinking about different ways to protect your intellectual property, your trade secrets, your confidential information. And then make sure and look at the agreements you're using. If you're going to continue to use your non-competes, you want to make sure there's a severability clause in there. And that's important because if the non-compete is invalidated, do you want the entire agreement to be invalidated? Most of the time, the answer to that is no. However, think about whether or not the agreement that contains that non-compete is going to have some tax implications, or if the non-compete goes away, but the whole agreement doesn't go away. And those are some executive comp kinds of things, some prohibited parachute payments, those kinds of things that you need to be thinking about and looking at. And then make your voice heard. If you have concerns about this rule, consider providing a comment to the proposed rule. And that's something that we can help with as well. If there are trade groups or particular employers that want help getting a comment submitted, we can help with that as well.
Sorry, I was muted. So the next one is also has already passed, and this is the Pregnant Workers Fairness Act. It is protection for pregnant women and new moms. It takes effect on June 2023. So you've got, basically 6 months to get prepared for this one. The EEOC is supposed to issue kind of guidance on this, but they have a whole year to do it after it's enacted. So we're not going to really know the EEOC guidance for a bit. But essentially, this act essentially closes the gap that there was in protection for new moms. So under the ADA, pregnancy itself wasn't considered a disability. I mean, if you had complications, that could arise to be a disability under the ADA, but just typically being pregnant did not rise to the level of a disability. And then you had the Pregnancy Discrimination Act, which did protect pregnant workers, but they were only entitled under that act to an accommodation for limitations if non-pregnant workers were given similar accommodations for things not caused by pregnancy. So again, it was just a comparator situation of pregnant women versus non-pregnant employees. And did we treat them the same, or did we treat them differently? So the Pregnant Workers Fairness Act essentially closes this gap. And it is reminiscent of ADA. You're going to feel like you're hearing a lot of ADA. So it applies to employers of 15 or more employees, and you have to provide reasonable accommodations for the known limitations related to pregnancy, childbirth, or any related medical condition of a qualified employee or applicant, unless the accommodation would impose an undue hardship. So that's where it sounds a lot like the ADA. So key things is you have to engage in good faith interactive process, just like you would if someone with a disability asked for an accommodation. You cannot discriminate or retaliate against an employee or job applicant who requests a reasonable accommodation for the known limitation. That is also very similar to the ADA. And here, I think this is key. You cannot require the employee to take paid or unpaid leave if there is another reasonable accommodation that can be provided. So if an employee says for the next 6 weeks, I've got X, Y, and Z restrictions, your go-to cannot be, we'll take 6 weeks of leave. Even if it's paid leave, you can't force the leave without going through the interactive process and determining whether or not another accommodation is appropriate. So a couple of things that I did want to highlight, and that is, so the known limitations, that's just them having to tell you, I'm pregnant and I have a lifting restriction, or I need to be able to sit, where maybe it's a job where they have to stand a lot and they need more breaks, some things like that. So they just need to tell you. It's hard to know until the EEOC gives guidance, but there is some indication that yes, you could seek some medical certification of the need for the accommodation, but be careful. There are state laws that have already got laws in place that are more restrictive than the Pregnant Workers Fairness Act. And they may or may not allow you to seek medical information. So I think that is going to be one of those kind of up in the air until we get some EEOC guidance, and always check the state law to see if there is another law that would be more restrictive. The other thing is a qualified employee. Well, that includes an applicant, as similar to the ADA. However, I think one thing that is interesting and it's a bit different is a qualified employee means an employee or applicant with or without reasonable accommodation can perform the essential functions of the employment position. That part's very reminiscent to ADA. Here's the difference: except that an employee or applicant shall be considered qualified if any inability to perform an essential function is for a temporary period. So that's going to be it's a different focus for pregnant than it is under ADA. And if the essential function could be performed in the near future, or the inability to perform the essential function can be reasonably accommodated. So that's a big difference from the definition under the ADA. So what will be seen to be a reasonable accommodation? Well, I think that will be interesting to see. I've looked at articles and, depending on the slant of the author, as to what some people might think is reasonable accommodations. Questions will be, do you have to create a light duty position for them? Say you have an employee that has a lifting restriction and their job is lifting 90% of the time. Do you have to create a light duty job where they are, stapling papers? What about a temporary transfer to a less physically demanding job? Do you have to give them longer, more flexible breaks? If you have a food and drink policy at your desk, do you need to make changes to that if someone that's pregnant needs to have water or food on a more often basis? You might have to look at, do you have to change equipment, devices, or workstation to accommodate a pregnant employee? Changes in uniform or dress code might also occur. So I think this is going to be one of those where it's definitely a law, but it's going to be unfolding as we get more guidance. In the meantime, once it takes effect, I think that you need to be of the mindset of how can we make this work versus that's just not doable. So I think you do need to come with a mindset of how can we make it work. All right, and I think the next slide is also protection for mothers, and that is PUMP Act, Providing Urgent Maternal Protections for Nursing Mothers Act. And this expands what was already put into place with an amendment through the Fair Labor Standards Act, which said that for non-exempt employees, you had to give them the ability to express milk, and you had to give them a sanitary private area that was, definitely private, and it just could not be the bathroom. So the difference here is that it now expands to cover all employees, and I do say with limited exceptions, and those are really certain industries that it doesn't apply to. But so this is going to cover your exempt employees as well now. And same thing, you have to give everybody a sanitary private area other than a bathroom to express milk. Break time may be unpaid for non-exempt, unless otherwise required by federal or state law. So but it is considered hours worked and must be paid if the employee is not completely relieved of duties. So if you have an employee who's taking a break to express milk, but takes papers in and is reading something for work or is doing a task for work, then for a non-exempt employee, that needs to be paid. Also, if an employee is taking what otherwise would be a paid break, you need to pay them. Exempt employees have to be paid for their breaks to express milk because they need to be paid their full weekly salary as required by law. The bill also extends from 1 year to 2 years this availability of the application of this act. It does exempt employers with fewer than 50 if compliance would result in an undue hardship. But again, it's hard to know if something is going to be hard to say that it would be an undue hardship. An employer could be financially liable for failing to provide accommodations to the covered employees. But before making a claim of liability, an employee generally has to notify the employer that you're not in compliance, and the employer will have 10 days to get in compliance. The only time you wouldn't have the 10 days is, let's say you've already terminated the employee because they wanted to take a break for expressing milk. And that time frame, you don't get the 10 days. But generally, you're going to get the 10 days. So some takeaways, and similar to the Pregnancy Fairness Act, there are for nursing mothers lots of state and local laws. So be very, make sure you're checking on those, because if they are more stringent, that is going to apply. You're going to want to look at and update handbooks and policies for compliance. And here's key. You want to train your HR and your managers on these new laws, because you don't want to have managers just automatically say no. They need to be trained to bring it to HR if an issue is raised. Be prepared to engage in the interactive process, and prepare the facilities for an increase in the need for the sanitary non-bathroom locations.
Okay, we have another big change that happened at the end of the year, and that is with respect to retirement plans, 401ks. And this is really the biggest piece of retirement plan legislation since 2019. It has over 90 different changes. We're just going to highlight a few key ones, and note that these are time dependent. So they make a lot of changes. They're not all at once. So we're going to highlight just a couple of the key things that are effective immediately, January 1, 2023, and then in 24, and then in 25. So the first big change you see here is with respect to required minimum distributions. They're changing that age. So it won't be until age 73 that you're required to take that distribution, and then that's going to increase over time. In addition, the penalties for failing to take it have gone down, and especially if it's corrected in a timely manner. The other big change is the Roth contributions being allowed by the employer. So before, an employee could make a Roth contribution, meaning after taxes, but anytime the employer made either a matching or a non-elective contribution, it was on a pre-tax basis. Now the plans will be able to make that a Roth contribution as well. 24. Let me highlight a couple changes that you can expect then. First off, this is very interesting with respect to student loans. So your employer contribution can be matched to the employee's student loan repayments outside of the plan. So basically, if the employee is having to spend money to repay student loans, then the employer, rather than paying the student loans for the employee could pay in the plan a matching amount of that student loan. I think that's something that employees are going to find pretty beneficial. Then this emergency savings account. Not sure how this is going to play out yet, but basically, if you want to, you can add to your plan so that there is a pension-linked emergency savings account. So these contributions would be made on a Roth basis, and there would be a cap, but something where they can access in emergencies. 2025, more changes. You're going to see a change in the increase in the contributions for the catch-up. So between 60 and 63, you're going to see an increase in that amount, and then it's going to be indexed for inflation over time. Then this one is, I think, really good if you're a little bit parental with respect to your employees. Basically, they've done studies and they've determined that what happens is employees go with the status quo. And so if a plan says you don't contribute and you have to opt in to make contributions, employees are less likely to do it. But if they make this change and have employees automatically enrolled and making their own contributions, employees are less likely to change. And so that's going to be something that in 25 plans can change to if they want to, and new plans will have. I think there's going to be, if you already have a plan in place that does it the other way, then you would not have to. But for new plans and existing that want to, it's going to be there. So hopefully that will encourage more savings. That's the goal. Then an expansion for part-time employees. In our new work environment, we're seeing more and more people working part-time. So they're addressing that to encourage savings as well by changing how you determine when a part-time person becomes eligible for the 401k. And so you're going to see that that's a lower number of hours in the previous 2 consecutive years in order to enroll. All right. What are your key takeaways? A lot of changes in this act. This would require its own webinar and a lot of detail. So rather than getting into all of that, we're going to tell you, you've got to know your plan's going to be impacted, and then stay on top of what's required each year. Coordinate with your outside administrators, those who are responsible for your plans, that they'll stay on top of it and make the recommendation on changes, but you're just going to have to pay attention to your plans very closely for the next few years.
All right, so next up is the Speak Out Act. It was enacted on December 7th, so it is in effect right now. And it is a limitation on the enforceability of non-disclosure, non-disparagement clauses, agreements relating to sexual assault disputes and sexual harassment disputes. So the why. The bill says that in order to combat sexual harassment and assault, it is essential that victims and survivors have the freedom to report and publicly disclose their abuse. So this is, I think, part of a reaction to the Me Too movement and a recognition that if prohibiting victims to speak out could have the ability of keeping things, the harassment and the assault ongoing. So that is the why for this. So there is a distinction, though, about pre-dispute non-disparagement and non-disclosure clauses versus post-dispute. And I think in one version of the bill at one point, it said that it could happen, you couldn't do it until there was a litigation. But then I think they recognized that might make it a disincentive for employers to resolve harassment or assault claims that have arisen before an actual litigation. So anyway, So they settled on pre-dispute language. So that is being interpreted to be if a claim is brought forward, whether it's internally, if somebody's gone to the EEOC, or I guess if they just went public with it, they have brought the dispute forward. But if it is pre-dispute, then non-disparagement and non-disclosure clauses with respect to sexual assault and sexual harassment are judicially unenforceable. So if you have a separation agreement, you're doing a reduction in force, or you're terminating somebody and you're giving them a separation agreement, and you have a standard, non-disparagement, you're not going to say negative things about the company, and a standard non-disclosure that says you're going to keep this agreement and everything about it confidential, then you are in violation of the Speak Out Act, because you need to have a carve out for anything with respect to sexual assault and sexual harassment disputes. So I think you can still have non-disparagement and non-disclosure, but you're going to need some kind of carve out in these agreements that allow these individuals to still speak out about sexual assault and sexual harassment. Now, if the dispute has been raised, then the act doesn't apply to agreements resolving claims already raised. But keep in mind that there may be other disputes regarding sexual assault or sexual harassment that have not been raised by employees. So employee X comes to you, raises a sexual harassment claim, y'all decide to settle it. You can have that be confidential. You can have everything regarding that claim or that dispute be confidential. However, you still have to carve out for anything that wasn't reported. So no blanket provisions there. It also, I think, is interesting that it may even be that the person raising it isn't even the victim, but I witnessed. So you can't prevent even witnesses from talking about and speaking out about harassment or sexual assault. Also, keep in mind, there are state laws that are maybe even more restrictive. So again, I think it's our mantra today, check state laws and make sure that you don't have something even more restrictive. There are certain states that have them, California being one, and I believe Illinois. There are definitely other states that have them, and some of them are even more restrictive. In fact, some of them even have a waiting period, like a 21-day waiting period for the individual to decide if they want to agree to it being confidential or not. But nothing in the act prohibits an employer from protecting trade secrets and proprietary information. So you can still have confidentiality provisions to protect your trade secrets and proprietary information. You can still have confidentiality, non-disparagement for anything but sexual harassment and sexual assault allegations. So I think you're still going to have them. You just have to be careful and have the appropriate carve-outs. So takeaways: review your employment agreements, confidentiality agreements, handbooks, policies, etc., to ensure compliance with the Speak Out Act and any applicable state and local laws. You're going to want to revise any template releases or agreements that you have to provide that carve-out language for pre-dispute, non-disclosure, and non-disparagement clauses. You're going to want to make sure for post-dispute agreements that you still provide a carve-out language for any allegations that are not subject to the dispute. And make sure your agreements have a severability clause. Natalie mentioned that earlier when she was talking about the non-competes. You want to have a severability here as well in case your confidentiality, your non-disparagement is found to be unenforceable. Unless you want the entire agreement to be unenforceable, you're going to want a severability clause. So the remainder of your employment or your agreement will remain in force.
The next topic we wanted to talk about are pay transparency laws. And these are a growing trend. We've listed the current states and municipalities that have those in place right now. So what are they? Basically, these are laws that say you must provide information about pay ranges either to applicants, to current employees, and maybe just in certain situations, sometimes in very broad situations. So I'm going to just look at a couple examples of these so you can get an idea of what these are. Obviously, North Carolina is not on this list. So if you're a North Carolina employer, you don't have this yet, but these things are coming, and it's also part of the trend in pay equity. So let's take a look at Maryland, for example. This is one that doesn't go quite as broadly. If you are an employer and you're engaged in business in Maryland, you're subject to the law. And what must you do? Well, if an applicant requests the wage range for a position, you need to respond. What's the penalty if you don't? If you did it wrong? Well, the first time it's likely just going to be a letter saying, did it wrong, you're compelled to do it right. After that, you start getting some fines per person that you don't respond to, okay? But this is more what the trend is. In Colorado, if you employ at least one person in Colorado, you're subject to the law. And it covers all postings. And I have seen, since this law went into effect, a lot of postings that say we don't accept applicants from Colorado, trying to get around this requirement. Well, the guidance that has come out for their enforcement, that doesn't matter. Putting that on there doesn't save you, doesn't get you out from under the requirements. So what does it cover? It's any work that is tied to Colorado in some way, or remote work that could be done anywhere. So it doesn't mean that you're looking for someone to do it remotely in Colorado, but if it could be done anywhere, then that would include Colorado and you need to comply. So Colorado is really trying to reach out there and cover a lot of employers and a lot of posts. Will they be ultimately successful? There obviously will be some legal challenges, but this is the enforcement position that they're taking. So the posts are both internal and external. So if it's you're seeking a new person to come into your company to fill a job, or you've got the position open internally and you're posting it for your employees, you have to provide the compensation range and a description of the benefits. A new position or an opening currently in a position that you have, if it could be viewed as a promotion to any of your employees, that means it's a better title, it's better pay, it's better in some way that I would interpret it to be a promotion, then you need to make sure that you're giving the employees instructions on how they apply, what the title of the job is, and the description, in addition to the compensation range that's already covered. So that's very, very broad. Penalties are not like they were when we looked at Maryland. This is a criminal misdemeanor, fines and civil penalties, and it can be substantial. So this is the trend. Colorado is an example, but Washington State, California, very broad reaching laws as well. And this is likely to continue because we have a divided Congress at the federal level. So I think you're going to see states continuing to enact these types of laws and some others that we'll sort of talk about at the end. Specifically watch Michigan, Minnesota. They do not have divided chambers. Both houses have Democrats. And so they're two places you're going to want to be looking to see what the trends are. There's going to be a lot coming out of there, I expect, including things related to wage transparency. So what do? You got to start reviewing, know what the pay ranges are for positions. How are you identifying those pay ranges? What laws apply to your postings? Remember that your internal postings are impacted by some of these laws, and just start planning for compliance because this is a trend. It's not going away. It's going to get broader. And that actually leads us quite well into what Trish is going to talk about.
All right. So the EEOC, I guess every 4 years, puts out a new strategic enforcement plan. And so they have a new one for the 2023 through 2027. Right now, what they've released is a draft, and it is open for public comments until February 9th. And the final plan is subject to approval by a vote of the commission. So here's a prime example of, I might be talking about something and it could change by the time it's actually becomes their strategic enforcement plan. So what I'm going to talk about is the draft. And the purpose of the strategic enforcement plan is to help the EEOC to focus and coordinate its agency's work over a multiple fiscal year period and have like a sustained impact on advancing equal employment opportunities. So the first one they had was for 2013 through 2016. And then they had one for fiscal year 2017 through 2021. So what I'm going to talk about is the new proposed one. And just know that some of these have been in all their other strategic enforcement plans. So it's not like they start from scratch and they just pick some new things, but they do change a bit and they ebb and flow, or their focus may differ a little bit. So the first thing I'm going to mention is eliminating barriers in recruitment and hiring. They are going to be focused on AI and access to training for employers. So if you rely on, and this comes up in several places in their strategic enforcement plan, but if you rely on automated functions for recruitment or selection, even performance management tools, then you need to be really careful, because they're going to be focusing on whether or not that is discriminatory or has a disparate impact on particular groups. So make sure what you're using, you feel confident about. It does not mean you cannot use it. Just make sure you're confident that it is not having some kind of disparate impact. The next is they are going to be protecting vulnerable workers and persons that are from underserved communities from employment discrimination. Of course, they always do this, but who they view as a vulnerable workers does change some. And so what they're saying right now is that it's people with intellectual and developmental disabilities, individuals with arrest or conviction records, the LGBTQ, individuals, temporary workers, older workers, individuals with low wage jobs. So that's going to also probably include a lot of your younger workers, your teenage workers who might be doing some of these low wage jobs, and persons with limited literacy or English proficiency. So that is how they're defining a vulnerable workers and persons from underserved communities. The next thing is they are going to be addressing selected emerging and developing issues. And so some of those include inflexible policies or practices that discriminate against individuals with disabilities. So this is a good time to go back and look at your attendance policy. If you have no fault attendance, things like that, make sure that you are allowing for exceptions for those with disabilities. They're going to be looking at pregnancy discrimination, especially with the new act. Backlash discrimination due to current events. And what that means is with COVID, did that have a backlash on some nationalities where people started discriminating against people of a certain nationality because they blamed them for COVID, or just something in the news that might happen that could make people backlash and start focusing discrimination on a particular subset. And then you're going to have your technology related discrimination, as I mentioned before. So this is where I'm saying they've mentioned it in numerous different ways. So I do think this is something they're going to be looking at, but that algorithmic decision making, automated recruitment, selection, etc. So again, be very confident in that tool that you're using. Advancing equal pay for all workers. So that is partly what Natalie was talking about, was all state laws, and it didn't include any kind of law governed by the EEOC, but the EEOC is going to be getting into that as well. And they're going to focus on employer practices that could impede equal pay. So pay secrecy policies. If you have a policy in your handbook that says you cannot discuss your compensation with anybody, you need to remove that. That is something that the EEOC doesn't like. It violates numerous other laws as well. You can't retaliate against employees for sharing pay information. So again, this is something that I think training your managers so they are well versed in knowing that you can't reprimand somebody for discussing their pay information with others. They're going to be looking at whether or not employers are relying on past salary history to set pay, and whether or not they're requiring applicants to specify their desired or expected salary at applicant stage. So I think EEOC is going to get their foot in the door on these pay inequities as well. And then you have preserving access to legal systems, which again has been in their previous plans as well, but it is focusing on overly broad waivers, releases, non-disclosures, non-disparagement agreements, things that they would deem to be unenforceable, such as something that would impede an employee's ability to go file a charge with the EEOC. They're going to also be looking for improper arbitration provisions, and failure to keep required applicant and employee data and records. And they're, like always, looking for retaliatory practices. That's always been a hot button for them because they don't want anything to impede or infringe upon an employee's ability to go to the EEOC. And if they hear Natalie went to the EEOC and Natalie got fired, that's going to probably chill people from wanting to go to the EEOC if they think they're going to get fired. Another is preventing and remedying systemic harassment. So the EEOC gets a lot of bang for their buck when it is a systemic harassment. And if they want to file a lawsuit, EEOC versus employer, they typically want it to be something that is systemic harassment where they're really going to be ending. Not saying they don't care about the individuals, they do, but systemic harassment is a big focus of theirs. And they have targeted a couple of industries, which is high tech. They don't define high tech, they just say high tech, and construction. These two industries have been called out for closer scrutiny. Another thing I wanted to make sure you were aware of, and that is that there is a new Know Your Rights poster that from the EEOC. So you need to make sure you have the updated poster.
The next area that we really have a new landscape in is labor law. And we did a labor law focused webinar towards the end of last year, I think maybe October or November. And if you missed that, go back and check it out, because it talks a lot about what concerted activity is and how it doesn't need to be a union environment, and how much enforcement there is and awareness by employees about this. I'm not going to talk about that right now, but I really encourage you to go back if you're not familiar with that and take a look at that webinar, because you need to make sure your policies are up to date and you don't have blatant things in your policies, like what Tricia mentioned, not talking about compensation or things like that. That could be viewed as prohibiting concerted activity. But the whole landscape for labor law has changed. There's a new joint employer rule. This came out and the comment period has closed, so we are likely to get the final rule very soon. Why does this matter to you if you don't have a union? Well, it matters because the way they're going to look at this, it's going to be very easy to be considered a joint employer. And if you're a joint employer and the other employer has a union, you would have to bargain with that union. And or if there's a labor dispute with this other employer, they can come and picket you if you are a joint employer. So there's a lot of implications for this. There's also now a trend towards smaller bargaining units, which means easier to unionize and get unions into certain work environments. And why, what's the difference here? The NLRB has changed the standard so that instead of saying we have to look at who would be included in the bargaining unit and who would be excluded to determine if people are being excluded that shouldn't be, you only have to look at those who are being included. And then it's the burden of the employer to say we excluded someone that we shouldn't have. Why does that matter? It matters if there's initial unionization and you're going to have an election, and what's the pool of people who are voting on whether or not we're going to have this union. So it becomes very important. We're also seeing changes to how they enforce rights. When there's an unfair labor practice charge, it used to be we need to make them whole, and making them whole if the employer was found to do something wrong meant back pay. Well, that's not what it means anymore. Under this board, they are seeking complete make whole remedies, and even if there's a foreseeable pecuniary harm, then there should be compensation for that. That's very broad. Monitoring is another area where they've gone and really taken a stance. And they're basically, it's similar to what you're hearing with the EEOC and the AI. They're looking at this stuff closely. But for the most pressing from the NLRB standpoint, the labor law is, are you doing any employee monitoring? So, you know, video security is so common now. And what they're saying is that if you are monitoring your employees to the point where they're not comfortable having confidential conversations about their pay, about their terms and conditions of employment, you're in violation of the National Labor Relations Act. So are you monitoring? Certainly, I hope you don't have a Ring device at your workplace. If you do, you need to be on alert to this. Finally, property damages. There's a Supreme Court case that is being considered right now. And trying to go a little quickly here, but in short, if you were to have a union strike, you know that things that violate the law, violence, purposefully damaging property, you can go to the state court and you can get an injunction, you can get the police, you can get people to step in and help you as the employer, right? Because that kind of activity is not protected by federal law. But if the activity is protected by federal law, then the states can't do anything. And that has to go through the whole NLRA process and the federal courts and all those kinds of things. So it's very important to determine if what happened was this intentional act or not. Supreme Court's going to hear this case that's very interesting because it's a concrete company and the workers went on strike. And when they went on strike, they left trucks full of concrete at customer sites. Well, any of us who know anything about concrete knows that product was ruined. And so the question here that the Supreme Court is taking up is, was that reasonably foreseeable? Is that the same as some sort of intentional act of violence, intentional destruction of property, or is that just a natural consequence of them withholding their labor? Makes a big difference on what types of things people are going to be able to do. And it's the one area here that possibly has a trend in favor of the employer based on who we've got on the Supreme Court right now. And that is, if there is a bigger chance that unions might be held responsible for property damage, the risk of the workers walking out increases. So it potentially could have a little bit of pushback on work stoppages if it goes in favor of the employer. If it goes the other way, then it's going to be very hard for an employer to show intentional acts of damage versus just a natural consequence of them withholding their work. So what's your takeaways? I really want to emphasize the monitoring. if you are monitoring, if you've got video surveillance, even if it's for security purposes, you're going to have to figure out if it's really required in the areas that it is, or if it could be inhibiting your employees from having the ability to have confidential conversations about their terms and conditions of employment. That joint employer rule, workers that you think aren't yours, they may be when this rule is finalized. And then keep in mind that there are a lot more damages available for an unfair labor practice charge than there ever have been before. All right. Now, there's a lot more that we could talk about. I'll flip back to Tricia and let her get us started here. Running out of time though.
Yes, as Natalie has highlighted, we see a lot on the horizon for 2023 that aren't new yet, but could be. So we're going to talk about several Supreme Court cases that the Supreme Court has agreed to hear, but has not ruled on yet. Some are employment cases, some are not, but could still have an impact on the workplace. There are going to be several areas where regulators have said they plan to act, and there continues to be fallout from COVID, remote work, the Great Resignation. So we don't have time to get into all of these items in detail, but we're gonna highlight a few, up and coming issues and things to be on the lookout for. So this is a Supreme Court case. It's 303 Creative versus Elenis. Hope I'm pronouncing that correctly. This is not an employment case, but it is a religious rights case. So Colorado has an anti-discrimination act, and it prohibits businesses that are open to the public from discriminating on the basis of numerous characteristics, including sexual orientation. And the act also prohibits publishing any communication that states or implies that a person's patronage is unwelcome due to a protected class. So 303 Creative is a graphic design firm, and the owner wanted to expand her business to include doing wedding websites. However, she opposed same-sex marriage on religious grounds. And so she wanted to post a message on her website explaining her religious objections to same-sex marriages, same-sex weddings, and provide names for other businesses that could do a wedding website for them. But that would be in violation of the Colorado Anti-Discrimination Act. So she went ahead and filed the lawsuit. The business owner filed a lawsuit challenging the law, alleging numerous constitutional violations, including First Amendment. The district court and the Court of Appeals found in favor of the state and said that the law did not infringe upon the business owner's constitutional rights. But this has now gone up to the Supreme Court, and they heard arguments on December 5th, but we don't have any rulings yet. So it's going to be interesting to see how the court handles this and how they see the religious rights in this context. And so looking at the next case is again about religious rights. It's pending before the Supreme Court. I don't believe arguments have been heard yet. And this is an employment situation. This is a scenario where Mr. Groff observed Sunday Sabbath. He worked for the post office, and the U.S. Post Office back in 2013 evidently signed a contract with Amazon to deliver their packages on Sundays. So you may not get the U.S. mail on Sundays, but you've got U.S. postal workers out there delivering Amazon packages. So they all had to take turns working on Sunday. And Mr. Groff objected due to religious reasons that he did not want to work on a Sunday. The post office tried, they transferred him for a bit to another post office where they were not delivering packages on Sunday, but then they also started delivering packages on a Sunday. So as demands increased, they needed him to work the Sunday shifts again. They tried to accommodate him by taking volunteers to work his Sunday shifts. That worked for a little bit, and then that didn't work anymore. And so eventually he got in trouble for not working on the Sunday shifts. So he was terminated and he sued. the current standard for making an accommodation under the Title VII for religious discrimination is that it has to be more than a de minimis cost test for refusing a religious accommodation. Just pretty low. It's very different from an undue burden under the ADA, where, you know, that has got to be it's a pretty high bar to prove undue burden. This one's a pretty low bar, just more than a de minimis cost. So, and it allows, the current standard even allows for, it impacts our employee morale when somebody doesn't have to work the Sunday shift and other employees have to take that person's shifts. They don't think it's fair. It impacts our morale. So right now, that is the standard for Title VII religious accommodations. So one of the issues is whether the court should disapprove of this more than de minimis cost test, and whether an employer may demonstrate undue hardship on the conduct of the employer's business under Title VII merely by showing that the requested accommodation burdens the employee's coworkers rather than the business itself. So that could be it could have a dramatic impact on religious accommodations if the standard for an undue burden changes. So it is a time where the Supreme Court could kind of scrap the employer-friendly precedent and go with something that's more employee-friendly. So it's definitely one to watch.
This is another non-employment case, but it is definitely one for you all to watch as employers. This has to do with the ability of universities, private and public, because there are two cases, one of each, to consider race and diversity in their selection of students to make up their class each year. There's a group challenging that, saying that shouldn't be allowed. How does it have an implication for you all? So one of the arguments in the case, and that has been the case, is that we need a diverse student body in order to deliver the best education we can. And that sounds a little bit similar to what we've been saying as employers. We need a diverse workforce in order to have better decisions made, to better reflect the people that we are serving or the consumers of the products we're selling. All of these things sound very similar. So if the Supreme Court were to say that this is not okay for universities, private or public, it could have some implications for employers, especially in light of the Novant case, which I'm pretty sure most of you are familiar with, but basically it was a white male claiming that Novant was seeking more diversity in its upper management, and that resulted in his termination. Novant had stated, we want to have a executive workforce that more closely reflects the people we serve. And he won a jury award of $10 million. That was later reduced because of some of the caps on punitive damages, but it still ended up being, I think, $3.9 million in back pay and front pay and the punitive damages. So there is a lot that the Supreme Court is doing. A couple other cases, they have not yet said yes, they will review, but have gotten their attention enough to make some inquiries to find out the government's position on. And that is what is an adverse employment action? Right now, as employers, one of the first things you do if there is a complaint is put somebody on on a paid leave pending an investigation. One of these cases is challenging that and saying that itself is an adverse employment action. Another one is challenging, saying that it's an adverse employment action to transfer somebody to a similar position with equal pay, but the person says it's less prestigious. So it's a negative employment action. So we'll see if the Supreme Court takes those up, but just wanted you to know they're out there. And we are out of time. So very quickly, some of the other things we have on our list, you're going to see a new I-9 forms and possibly permanent remote I-9 compliance. You're going to see probably changes in those salary basis numbers for exemptions from overtime, and a lot more going on. We'll stay for another minute or two if anyone has questions. Are there any in the chat? There's none in the chat. Okay, great. So if there are no questions, we will go ahead and close. I think this is where we will end the recording, and those of you who are seeking SHRM